Welcome to the Earning Freedom Program. Today, I am excited to introduce you to my friend, Diane Bass. Diane is one of the premier criminal defense attorneys in Orange County, California. She specializes in federal courts. And I'd like to ask you today, Diane, tell us a little bit about how you got involved in the federal judicial system.
I was really fortunate after working at the Orange County Public Defender's Office for a couple of years. I applied for a position on the Criminal Indigent Defense Panel in Santa Ana. And I was given the opportunity about 20 years ago to start taking these federal cases that were appointed to me by the court as a private practitioner. And there are only a handful of lawyers that do this work. It's a sought after position. And as a result of being in that position, I was able to handle every kind of criminal case that came across the bench. And it was truly an extraordinary learning experience.
And then you came to specialize, didn't you, in the federal judicial system primarily, not state and federal, but primarily federal cases. And I know that you place a lot of emphasis on sentencing. Tell us a little bit about the types of services you provide to people who are facing a sentencing hearing in federal court.
So sentencing is something that's almost inevitable in most federal cases. About 90% of federal cases end up in either a plea or a conviction in one way or another, and therefore they end up in sentencing. And this is ultimately the most important part of the case because this is where the judge determines the sentence. I start preparing for sentencing in most of my cases from day one. I start gathering information from my clients about their personal history, their background, as well as any sort of service work they've done, any diplomas, certificates they may have. And I ask my clients to gather information, get character letters from as many people in their lives as they possibly can get, find me information about things that they've done, accomplishments that they have. And additionally, if there is the need perhaps for a psychological evaluation, I will send them to a clinical psychologist and have a workup done. There are many different kinds of cases where that becomes an issue, more than you would imagine. If there are medical issues, I have people gather doctor's records, medical records. There are just any number of things that we start doing right from the very beginning of a case.
A lot of people who go into the criminal justice system, particularly in federal prison, don't have attorneys that spend that much time preparing them for sentencing. Have you worked, or could you tell us a little bit about whether you only work for your clients, or do you also specialize or do provide a service for people, for other attorneys that may need assistance in preparing their clients for sentencing? And if you do, tell us a little bit about that.
Yeah, I am absolutely available to help other attorneys with their clients and get them ready for sentencing. Sentencing is a huge piece of the puzzle, and it's something that a lot of other attorneys don't focus on. I know of attorneys who, just do the bare bones. And it's a really unfortunate situation for those defendants because there's so much that can be done for clients at sentencing. So yes, I absolutely offer my services to other attorneys or defendants who have attorneys. They would, of course, have to talk to their attorneys about it. I can't talk to them when they're represented. But it is something that I'm happy to do and collaborate.
Now, a lot of defendants who go into the federal criminal justice system hear something about the federal sentencing guidelines. Tell us a little bit about what the federal sentencing guidelines are, and if it's something that really just pigeonholes a judge into sentencing somebody, or if there's any wiggle room. Tell us about the sentencing guidelines.
So the federal system is unique from any other system because of the federal sentencing guidelines. And the sentencing guidelines are a set of rules that were drafted by Congress, which set out sort of the parameters of sentencing. It's the starting point for any sentencing in federal court. So basically, it's a book. This is it. It is the United States Sentencing Commission Sentencing Manual, Guidelines Manual. And all of it is really distilled into a chart that's at the back of the book. And if you can see, I'm just giving you a general idea because obviously you can't see all of it. But basically, in this column here, there are a number of levels. And in the top column here is a person's criminal history category. And then in here are months. So every sentence or every offense basically has a corresponding number of levels that go with the offense. Those levels correspond to a number of months. Then there is a procedure for calculating a person's criminal history category based on points. So the probation office generally determines the criminal history category They look at a person's priors, how old they are, how much time was spent, and then they determine where they are on that part of the chart. Then you take the two parts, the offense level and the criminal history category, and you come up with a number of levels. And that corresponds to a number of months that are the starting point for the judge to consider for sentencing. Now, there are factors, though, that the Sentencing Commission do not take into consideration. And since 2005, the Supreme Court made the sentencing guidelines advisory only. They used to be mandatory, and the court had to follow them except for a few small exceptions. Now courts have discretion, and they use their discretion. And that is where I come in. There are many factors that the court takes into consideration. And the most important one for defending somebody who's charged in the criminal case is the history and characteristics of the defendant. There are about 7 factors, but that's the one that I really, really focus on, as well as the nature and circumstances of the offense, because there may be mitigating factors. And so that's something else that we talk about. And of course, I talk about all of the factors in my sentencing arguments, but that's really primarily where the strength of mitigation comes in at sentencing.
You mentioned a probation officer having some influence on that sentencing process. Could you tell us when the probation officer becomes a factor in preparing an individual or influencing the sentencing process?
Yes. So after a defendant pleads guilty or is convicted in a federal case, the probation office is ordered to prepare what we call a pre-sentence investigation report. We call it a PSR. My understanding is at the Bureau of Prisons, it's referred to as the PSI. In any event, it is a document that looks like this. It's about usually 25 pages long, and it contains everything about the defendant. It contains information about their personal history, their background, family, education, employment, criminal history, offense conduct, and then there is a recommendation letter that goes along with the PSR, which is where the probation officer actually makes a recommendation to the judge about the appropriate sentence, and they give reasons why they believe that this is an appropriate sentence in a section called justification. And they will talk about factors in aggravation and factors in mitigation. And these are all of the factors that we address then in our sentencing memo.
So when a client comes to you, what level of understanding does he or she have with regard to this pre-sentence investigation report?
Most people don't know anything about it, and if they do, it's just what they've heard from others, but it's very vague. This is something that, generally speaking, I will spend some amount of time talking to my clients. Well, certainly I spend a great deal of time preparing them for the PSR, but as far as the process is concerned, a probation officer will meet with us, whether they are out of custody or in custody. We go to the probation office, or the probation officer goes to the jail, and they go through a packet of questions, and they ask us if we have anything additional that we'd like to add. But there is a great deal of preparation that I do with my clients prior to that meeting. And then the clients are told that this pre-sentence investigation report will be prepared. They will have time to review it with their attorney, and they can make any corrections or objections that they deem necessary prior to sentencing.
And in what ways does the finished document really influence the judge at sentencing?
Well, it is the first document that the court sees prior to sentencing that contains information about the defendant. So it really does have an influence. Now, I pride myself on making very compelling arguments at sentencing, so I like to say that the probation report really doesn't have that much impact, but I may be in denial. I think that it's certainly a very important document, again, because it's the first thing that the judge sees, but it is something that I almost regularly disregard as far as its recommendation if I disagree with it, because it really hammers on the sentencing guidelines. And I don't like the guidelines. There are a lot of judges who don't like the guidelines. I want the judge to do what's right. I don't want the judge to be following just a chart when they're sentencing my client, who's a human being.
So you'd mentioned that the probation officer puts a lot of information in there about the defendant's past. why don't you tell us what a defendant can do proactively to influence the outcome of that pre-sentence investigation report?
So this is really the most important part of the case, in my opinion. Preparing for the pre-sentence report is an opportunity to have your version of your life and the conduct, the offense conduct, integrated into the PSR. So the first thing that the judge sees is actually your side of the story, not the government's, not the discovery from the case or the FBI reports or whichever agency is involved, but your side of the story. And right from the start, we can start to build a sense of compassion and sympathy and empathy for the client in the judge's eyes. So what I generally do is I have my client prepare a letter that first and foremost contains a very sincere statement of remorse, which is one of the most important things that the judge wants to see. But then also I have them really go into detail. And oftentimes this requires some very deep soul searching. It can be very emotional for some people, but it has a tremendous impact on the outcome. And the more detailed the letter is, the more detailed the information is about their remorse, about their history, about what led them into the offense conduct, if there is drug addiction, if there is mental instability, if there is a horrible, tragic family history, which is most often the case, if there is some sort of abuse. These are all of the things that I want in the letter so that the probation officer essentially can cut and paste from my client's letter and put it into the probation report so it becomes something that we have much more control over. And what I have found is that when we go to the pre-sentence interview with the probation officer, they're very appreciative that we've provided them with all of this information before we've even started. And then if they have follow-up questions, they can dig more deeply into these areas and sometimes end up providing even more mitigation just from where we've presented this information.
So many of the defendants that I've worked with in the past really lack that level of ability to introspect and express it because they're still living in a state of denial, and a lot of times they are reluctant to provide that type of detail. In what ways can you work with a defendant who doesn't quite know how to provide that level of detail that you're looking for about his background, about what led him into the offense, about really accepting responsibility? In what ways can you work with a defendant who is really just not in a frame of mind? His life's spinning out of control. He's afraid of losing his family, his business, his reputation. What can you do with that type of defendant?
Well, most often, Michael, I send them to you. And I have had extraordinary experience with my clients who have come to you, and you spend hours with these people. And you just seem to have this way of not only writing the narrative beautifully, but getting the person to dig down deep and to accept what's happening to them because you've been there. And this is a perspective that is extraordinarily rare, and it's something I certainly can't provide my clients. And you have this magic touch, I may say, an ability to get people to really express everything that's important. And every letter that I've written every letter that I've read that you've assisted my clients in writing has been tremendous. We've had tremendous results. We've had that reaction from probation where they have been appreciative of the work and also visibly moved. I have seen just recently, last week, a probation officer had tears in her eyes because she was familiar with my client's background, everything he was going through, the steps that he was taking to show his remorse. And I have known this particular probation officer for almost 20 years, and I've never seen her move to tears. So that was quite extraordinary.
You know, to be truthful, whenever that happens, it's really the defendant's words that are coming out. It's just a matter of questioning and getting and asking questions so that the defendant is really revealing that remorse and how he or she is identifying with the victims and starting to see. Just really the idea, I think, in that narrative is for the defendant to be able to help those who are reading about him see that person as a human being and a common humanity. And although not explain away what happened or excuse what happened, but really just talk about how did I get here. And I do think that you provide your clients with a great service when you help them recognize this is perhaps the biggest sale they are making in their life, where they're having to show a judge and others stakeholders what why they're different, why they are something more than simply the criminal charge. But my next question, Diane, has to do with how the PSR influences other stages of the process. Could you tell our audience how whether the pre-sentence investigation report can have some type of influence on an earlier release even after sentencing?
Yes, so there is a program in the Bureau of Prisons called RDAP, which is a 500-hour drug treatment program, and it applies to people who have alcohol or drug issues. If their substance abuse is accurately reflected in the probation report, then the judge at sentencing can recommend to the Bureau of Prisons that the defendant participate in the 500-hour drug treatment program. As a result of their participation in this program, they can get as much as a year off of their sentence. Aside from that, which is an extraordinary benefit, I have heard that it is an excellent, excellent program, and people who have done the program have great success in staying clean and sober. So it's a great program, but it also, a year off of your sentence is extraordinary.
Well, thank you very much for sharing your wisdom on the federal sentencing guidelines, in particular the pre-sentence investigation report. We've been listening and learning from Diane Bass, a premier Orange County criminal defense attorney that has a real specialty practice in preparing individuals for sentencing. And you gave us some really extraordinary statistics, Diane. How many of the people who are charged in federal court will eventually have a sentencing hearing?
About 90%.
About 90%, and that's why it makes sense to contact Diane Bass if you are facing a sentencing hearing anywhere in the country in federal court. Her contact information is above, and I hope that you will have the best possible experience if you're facing charges in the federal criminal justice system. That's it for today with Earning Freedom. We'll be back soon with another inspiring message or message that you can use as you prepare to navigate the challenges of the criminal justice system. Thank you.
Thank you.